Peace, everyone. Welcome to Moorish Monday with Abdullah Il Talib Mosi Bey. I have a wonderful guest with me tonight. He's not a stranger to the platform. Definitely, I'm excited about today's topic. Today's topic is due process, the key to freedom. Due process, the key to freedom. So you'll see before we get into it, I want to thank once again Hank for opening up this platform to me a year ago. This is my 1-year anniversary, so I'm definitely excited to continue with this platform in year number 2. I have a great lineup for you throughout the next year, 2025. We have some Brother El Kanan will be on every 4th Monday of the month. Brother El Kanan, 33rd degree, 97th degree, past Grand Master. He will be with us every 4th Monday of the month. Every 4th Monday of the month, dealing with masonry, astronomy, and mathematics. That is a continuation of a series. He'll be doing that throughout the year. And of course, King Albay will be us throughout the year, as well as I have Sister El Kanan will be with us next week. El Kanan will be with us next week, but El Kanan Bay. And then we have Sister Nitra. Sister Nitra will be with us on the 6th, January 6th, Monday, January 6th. She is a associate professor at one of the colleges in Maryland, and she's actually was one of the panelists on this past May 18th Moorish Political Unity Conference. We'll be rolling across the stream for the next 2+ hours at my website, mooresandmainstreet.org. So welcome. So we're going to, without further ado, Brother Israel, you're going to bring up the link, share the screen. Before King begins his lesson, once again, welcome to Moorish Monday with Abdullah Il Talib Mosi Bey. We're going to preview the market. We have the upcoming course, March 8th, 2025, more trust and contractual legal safeguards. So Brother Israel is assisting us tonight, and he will share the screen. All right, so as soon as he shares the screen, all right, here we go. Brother Israel, would you do us the honors?
Indeed. Let me get to it.
So Brother Israel is going to read.
All right, peace. So Moorish Investigative and Research Committee, educational lessons on the Moroccan Post Media YouTube page, free recorded lessons. Moroccan Post School of Government and International Law, Terrence Bey, Shem Malachi Bey, and Abdullah El Talib Mosi Bey. Moorish Union of Sovereign Tribes, King El Bey. Session 1, the basics of criminal investigation, the meaning of evidence, finding of facts, and conclusion of law. Session 2, introduction to the application of law and evidentiary standards, part 1. Session 3, introduction to the application of law and evidentiary standards, part 2. Session 4, using legal principles to draft motions and pleadings, part 1. Session 5, jurisprudence/philosophy of law and legal principles as the foundation to run government and to handle legal cases. Session 6, using legal principles to draft motions and pleadings, part 2. Session 7, the use of affidavits, notary processes, and notary presentments.
All right, so this is what's the next slide? You have the YouTube page, the Morocco. The next these are pre-recorded classes, lessons that that's on the Moroccan Post Media YouTube page. You can go to the Moroccan Post Media YouTube page for those lessons.
Mhm.
And all of them are PowerPoint lessons. All right, continue.
All right. This is the trust and contractual legal safeguards. This 12-week course provides an in-depth exploration of trusts, contracts, and legal mechanisms that safeguard them. Our course, Master Trust Functions, discover the role of a trust protector, intellectual property law, demystify assigners and assignees, understand power of attorney, navigate licensing, leasing, and renting, strengthen your contracts. Duration, 12 weeks. It's a 12-week course. Start date, Saturday, March 8th, 2025, 2 p.m. to 5 p.m. Eastern Standard Time. Format 100% online with live question and answer sessions. Tuition, $299, Federal Reserve notes and 99¢. Register now. For more information, phone, you can call 215-300-5471.
That's
Etymology.
me, y'all. That's my number, 215-300-5471.
All right. Or email at etymologyvocabulary@gmail.com. This is the legal principles, a book coming out, Legal Principles, the DNA of the legal system, Legal Principle, by Brother King L. Bey and Brother Abdullah L. Talib Mosley Bey. So, understanding due process, the key to freedom, presented by Word Step Study Group with the Moorish Investigative and Research Committee. So, rule of law. Governments need to have good laws, institutions, and processes in place to ensure accountability, stability, equality, and access to justice for all. This ultimately leads to respect for human rights and the environment. It also helps lower levels of corruption and instances of violent conflict. This concept is called rule of law. It affects everything about where people work and how they live. By having a strong rule of law, governments give business and society the stability of knowing that all rights are respected and protected. A strong rule of law includes clearly written and easily accessible laws that create certainty and enforceability of legal rights, an independent and impartial judiciary that promotes fairness and ensures transparent, timely, and predictable resolution of disputes, effective and efficient public institutions that empower business and individuals to make a positive contribution to the economy and society. There are great benefits to business and other stakeholders in respecting and supporting the rule of law. Where the rule of law is weak, it is harder for responsible businesses to function and to meet their legal obligations and have legal rights protected. Companies need governments to offer a strong rule of law so that businesses can meet their commitments to universal sustainability standards, including the UN Global Compact's 10 principles. Constitutional due process. Constitutional due process refers to a legal principle enshrined in the 5th and 14th Amendments of the U.S. Constitution, guaranteeing that government cannot deprive a person of life, liberty, or property without due process of law, meaning it must follow established legal procedures and provide fair treatment before taking any action against an individual, essentially ensuring fundamental fairness in legal proceedings. Fifth Amendment.
Hold on, Israel. I just this is something I want to do. Brother King, I want you to tell us, why did you choose the title due process, which is particularly the subtitle. The main title for the day is due process. Subtitle, the key to freedom. Explain to us. So we're gonna put the camera on King. So before we get into that, I want King to explain the title. Why did he choose particularly as a subtitle, the key to freedom? Due process, the key to freedom. This is the day's title. All right, this is part one. Due process, because we might not complete this, so we'll deem this as part one. All right, go ahead, King.
Well, when I started understanding, first what sparked me was when I started learning, getting deep into law. I read a case law where the Supreme Court said the only thing we have to do is offer you due process. Your innocence and guilt was derived by the jury. So the only thing we have to afford you is due process. That's the only thing the courts guarantee. So as I started understanding what due process was, it led me down to the rule of law and the guiding principle. That was the guiding principle. And as I looked further down, I started understanding that equity was the birth of all things. And then as I started getting to the religious, it went from righteousness to equity to rule of law to due process. So understanding the operation and due process was the key because the court guarantees due process. And when most of us is not in don't understand all the components of due process. They don't understand the rule of law. So once I understood that, I started focusing on that before I started dealing with any legalities. I knew I had to understand what is due process from a substantive and procedural level. But I also had to understand it based on the rule of law, dealing with accessibility, fairness, right? No arbitrariness, right? Equal justice for all. And it's one more I can't remember. Abdullah, do you
Accountability.
accountability? So those things started. I started looking at that, and then I started seeing the operation of how the law works. Then once I broke that down, I went into understanding the operation of law, application of law, source of law, conclusion of law, findings of facts. I started breaking it down to these different components, and what it allowed me to concentrate my efforts, just not looking at the statute, because the statute could violate one of these principles. And if it violates a principle, then the statute is no good on its face. So I started understanding how the law is because once I understood how to utilize due process, I went on an 8 year winning streak, stopped losing cases. So I seen that was the key to freedom. Once I had a particular set of knowledge and skill set to be able to examine something based on the principle, not just the mere writing of the law. I had to understand how law is supposed to function, what they guarantee constitutionally, what they sit on, what they said, this is what we guarantee. And that now that I understand what they're guaranteeing, now I have to hold them under the fire of what they guaranteed. And that became my door to freedom because I understood how law operates. And then from there, it sparked a whole nother level of understanding of how to look at things, understanding how constitutions are derived. These principles of philosophies work hand in hand with these concepts. So once I was able to break it down, I started understanding. Then I understand a better understanding of due process from a substantive language level, looking at the language, and then understanding what due process dealing with on a procedural level, a right to be heard, a right to fair trial, a right to bring witnesses forth, a right a right to look at the evidence, right? These are rights that's guaranteed. Rights um, to challenge the law. You can challenge it. These are rights. You have a right to challenge the law, not just look at the law. You have a right to say that these laws, right? You have a right to an appeal. You have a right to a hearing, right? You have a right to withdraw your pleadings. These are rights that no one can take from you. Once I understood what due process was, and from every angle and every sense, and started understanding how to look at due process, and then, but I understood how it operates from the rule of law aspect, and how it's equity is in all of these things, right? And that it all stem to be righteous, right? Because that's where your rights come from, righteousness, right? That a man must be honorable in his dealings and he must be righteous in his actions. So equity, right? And then I started looking at how to look at the law, how to examine, how to challenge the law. What if this law that they created violates a due process issue or violates your fundamental rights? I was able to move forward and then be able to break all of this stuff apart and make it more simplified.
That was awesome, brother. It was important that you explained that because that's the title that you gave me, and particularly the subtitle, "The Key to Freedom." Excellent job, because it's important people to understand the title of today's presentation. All right, so go ahead, Israel. Just reread that, please.
All right. The whole constitutional due process. Constitutional due process refers to a legal principle enshrined in the 5th and 14th Amendments of the U.S. Constitution, guaranteeing that the government cannot deprive a person of life, liberty, or property without due process of law, meaning it must follow established legal procedures and provide fair treatment before taking any action against an individual, essentially ensuring fundamental fairness in legal proceedings. Fifth Amendment. No person shall be deprived of life, liberty, or property without due process of law. The 14th Amendment reads, no state shall deprive any person of life, liberty, or property without due process of law. Key points. Procedural due process. This aspect focuses on the specific steps the government must take before depriving someone of a protected interest, such as providing notice, an opportunity to be heard, and a fair hearing. Substantive due process. This aspect examines whether the government's actions themselves are fundamentally fair, meaning they can't infringe on certain basic rights even if they follow proper procedures. Application. The Fifth Amendment due process clause applies to the federal government, while the 14th Amendment due process clause extends the same protections to state governments.
Brother King, give us go into so we have here procedure due process and substantive due process. Can you give us a more extensive comparative analysis?
Okay. Well, procedural due process deal with the procedures in which they come with the rules of procedures. You got criminal rules of procedure, civil rules of procedure, traffic rules of procedures. You have administrative rules and procedures. You have various rules of procedures that you have to understand, you have to read, and that you have to understand, like the rules of evidence. These are procedurally standards, or like the rules of evidence. These are all standards of operation that they got to follow to the letter of the law. So when they violate any of those procedures or any of your fundamental rights as it relates to due process, a right to be heard, right to notice, a right to confront your accusers, a right to call forth witnesses, a right to be informed of your charges, these different rights, variations of rights. their violations. So substantive, you also have a right when we talk about substantive right, dealing with the fundamental part, right? You have to look at the statute to see if that statute violates a fundamental principle or right that you have. Did they have what they call legislative overreach? When they created that statute, did it reach over into a fundamental right that it shouldn't have reached over in? Did it give you notice? Do it meet all the due process requirements within this action of the statute? You got to look at the statute and make certain determinations based on your understanding of how the law is supposed to operate. Most of us don't understand it. So some of these statutes can be disqualified just by their mere operation because it violates fundamental rights and which violates due process. So you also got to look at the language in the statute and look and see if the language is appropriate. Could a reasonable person read it, right? Because one of the due process elements is reasonability. You have to understand, is this reasonable for them to ask someone to do? So when all of these elements, when you look at these things, you must be able to discern if this. So sometimes this stuff is you have procedural and substantive violations at the same time. And you got to know the difference between substantive due process and procedural due process. Procedural is dealing with the rules, right? A substantive component is that they violate your right to contract. That's a fundamental fairness, and that violates substantive due process. You have a right to contract unlimited when especially it's not dealing with something that the government owns. It's something that's dealing with a private right of action, dealing with the right to contract. The government can't get into that right of contract, and the government encroach upon that right of contract between two individuals, then the government, long as it's not considered illegal, right? Like selling dope or something like that. Me and you can't contract to sell dope. But me and you may contract to sell dogs. And if a statute violates that right, and as long as it doesn't have any effect on the government, then the government can't regulate it. So it'll violate a substantive due process issue. You can raise that up, and that you can challenge the jurisdiction based on the substantive rights. It violates due process, which is a constitutional guarantee that the statute don't meet constitutional muster as it relates to the language, that it fundamentally breaks down or encroach upon a fundamental right, your rights, that all men are equal in the eyes of the law, that is violated your rights.
All right. Next slide, Israel.
All right. Procedural due process, civil rules of procedure, and administrative rules of procedure under procedural due process. So civil rules of procedure established and enforced by the courts refers to the set of rules governing how a civil lawsuit is conducted in the courts, ensuring fairness and order in the process, secures the just, speedy, and inexpensive determination of every action and proceeding. Administrative rules of procedure established and enforced by government agencies, regulations created by government agencies to implement and clarify existing laws within their jurisdiction, essentially acting as detailed guidelines for how the agency will operate and enforce those laws. Governs how agencies function within their specific area of expertise.
Our brother King, you want to elaborate?
So once again, you have your rules and procedures, right? I told you, you got to be very familiar with the rules of evidence the rules of civil procedure, criminal procedures. Like in Ohio, they have the rule of superintendent. You have to be, every state have their different rules. Then you have administrative rules. Most people don't look at that administrative code. Like Ohio got the administrative Ohio revised code, the Ohio Ohio AC, Ohio administrative codes. So it's dealing with administrative agencies and their administrative duties, right? And they have to follow these administrative rules that most people don't even know exist because they don't check on them and read their administrative law as how it relates to the jurisdiction to ensure that the due process that they're using is accurate. So these are two different jurisdictions. So your civil rules is going to fall in within the state on the sense that these is going to be a part of the rules, but never let me forget about the court rules. You have also the rules of the court. In Ohio, they have what they call um, 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 the court rules. You got to know the court rules. Those are also part of the due process issue. A lot of people don't argue none of those rules. So you got the court rules, you got all of the other rules, and then you got the administrative rules. This if they're administrative agency and how it works.
All right. Next slide.
Procedural due process. The elements of civil rules of procedure. Commencing an action. A civil action begins when a complaint is filed with the court. Service of process. The summons and complaint are served on the defendants. Pleadings. All papers in the action are filed with the court and served on all parties. Motions. Motions must be in writing, state the grounds for the motion, and set forth the relief or order sought. Time. The day of the act, event, or default is not included in computing time. Technical issues. Courts can extend certain deadlines in appropriate circumstances.
All right, King. Then what you want to add anything you want to add to this? Elaborate.
Okay, so when we're talking about the procedural due process, the elements of the civil rules of procedure, right? So you got to understand that when we talk about commission of an action, you have to look at a complaint has to be filed and it has to be supported by facts. It can't be supported by hypotheticals. It got to be something that actually happened. So a lot of times, sometimes you would have in a complaint some narratives that's not actual, and you have to know what to look for to to just get the dismissal of the complaint based on the grounds that it's not based on something that was actual or factual. Then you got to have a right to be notified, service. So you have the right to be summoned on is who's complaining about you. If you don't know who's complaining, they got to give you an opportunity to cure the matter, right? You have a right to cure it. Then your pleadings, you have to know, they have to give you a right to plead on an action, plead guilty, not guilty, and plead any other things. Then you have a right to file your motions, right? By understanding these rules that you're in, the civil rules or criminal rules of procedure, or whatever was going on, you have a right to file motions according to those rules. And if a court don't allow you to have access to file motions, that's another violation of due process. And then everything is on a time constraint, or These rules have statutes of limitations. They tell you that certain rules have to be filed within a particular time, 14, 10 days. This particular motion has to be filed within the particular time frame, 30 days, 14 days, 10 days, in order for you to perfect that action on the motion. Then you got technical issues. That's examining if like for example, looking at a case back on violation of them having not preserving evidence or not. A lot of times, you got police officers who are coming and act as experts, but they don't know nothing about the equipment that they use. They don't have the manufacturer's manual to understand how that equipment is. So they'll talk about years of experience of using something, but they might not know nothing about the manufacturer's agreement or manual that actually show how to properly use the equipment or whatever. And they'll be going off the top of the head, and then they'll testify as if they're an expert. And you can say, well, here's some technical issues based on that, and because you cross-examined him and brought up the manual, the the um the manual, right? The manufacturer's manual that he might not know nothing about. So technical issues, there's a lot of things that can be a technical issue and that you have to be able to identify.
Awesome. Awesome. All right. Next slide.
Civil rules of procedure. Commencing an action, the cause of action. So commencing an action is the same as the cause of action. The existence of legal duty that the defendant owed to plaintiff. The defendant's breach of duty. The plaintiff's sufferance of an injury. Proof that defendant's breach caused the injury, typically defined through proximate cause.
Brother King.
My apologies, I'm putting it on mute. Okay, when we're looking at a cause of action, right, we have, like I talked about, an actual event. You got to file a complaint. You know, what are you complaining about? What was the legal duty that was owed? What did the law say that an individual has to understand and deal with based on his status, right? Like a lot of people don't understand how status works, because status is your relationship to persons, property, and things. So what is your relationship? Like, let's say if you had a noise ordinance, right? Your neighbor filed a complaint against you because you was making too much noise. Based on your status of being a resident of the state and a resident of that city, right? That would classify you, they would give them jurisdiction based on certain elements exist. And then they can utilize that to act upon you and file a complaint, right? Because you meet the criteria for them to perfect the action based on certain information that presented them the right to exercise. So you got to know these things. And then it's like a breach of duty. Like if you had, it's a statute might say, you know, if you're a resident, you can't do this kind of noise or whatever. And then it might the person might talk about the specific noise that you were doing that might disturb the peace and that they were up all night due to that and they had to work. And then you would talk about the injury. The plaintiff would say he can't work due to the fact or get any good sleep that affects his ability to work that will cause him maybe to be terminated due to your behavior, right? That cause him injury based off your conduct. Then we go proof of breach, cause the injury. Like I said, you would do actual affidavits. You would do things that would show and prove what he was doing, or you might have a recording of the loud music that you can demonstrate, right? what he was doing. You might have other videos. You might have people testifying against him, utilizing affidavits and stuff like that that could prove your point to show a direct relief why you can be granted such relief.
Good example. Good example. All right. Next slide.
The right to be informed of the nature of the action separate from the cause of the action. Sixth Amendment, United States Constitution, reads, in all criminal prosecutions, the accused shall enjoy the right to be informed of the nature and cause of the accusation. So what is the nature of an accusation? The nature of an accusation is one of the four primary jurisdictional laws under which an action is commenced against an accused. These primary jurisdictions are mentioned in Article 3, Section 2 of the United States Constitution. The judicial power shall extend to all cases in law and equity, to all cases of admiralty and maritime. Common law. It applies to civil and criminal cases and is based on the principle of stare decisis, meaning that courts follow precedents set by previous decisions. Equity law. Equity courts handle cases where legal remedies like monetary damages are insufficient, focusing on fairness and justice. Admiralty law. Admiralty jurisdiction is exercised by federal courts in the United States and covers cases involving maritime contracts, torts, injuries, and offenses. It is distinct from common law and equity law and is governed by international conventions and treaties. Maritime law. Maritime law applies to activities on navigable waters and is governed by international conventions and treaties.
Brother King, elaborate.
Okay. So when we talk about the nature of an action, right? You have a lot of times the court won't identify one of the common jurisdictions, the four constitutional jurisdictions. That's what we need to identify. What is the constitutional jurisdiction that's identified that you have a right to be informed of, right? A lot of times they won't tell you if it falls under the common law, equity, admiralty, or maritime. And by that concealing that, that's a constitutional violation in which you can ask for sanction. Now you can ask that the court or the prosecutor be sanctioned for concealing a jurisdiction due to the fact that the defendant cannot make a common defense or to defend himself based on the laws that's going to fall under either one of those categories under those constitutional laws. So if they don't identify, you can show where that's a violation per Constitution, right? That's something that the Supreme Court has to deal with, right? Because they guarantee due process, and that was in the interest of justice, right? You can let them know this is based on the interest of justice, and that it covers all. This is a violation of the Fifth Amendment and 14th Amendment. Right? If a state doesn't do it, that's constitutionally governed by either one of those due process issues, and then you can argue that these are issues that's constitutionally granted that now you have a right to file a particular original actions dealing with that constitutional ground.
All right. So we have here. So we love the nature, the right to be heard, to be informed of the nature and cause, the nature of the action separate from the cause of action. All right. So we already talked about. You already explained the cause of action in the previous slide, and this one is the nature of the action. All right. Next slide.
Civil rules of procedure. Service of process. A party in a lawsuit or legal proceeding gives to another party an appropriate notice of the initiation of legal action. What does it involve? Delivering legal documents, usually including a summons and complaint to the defendant. Purpose: to officially notify the defendant of a lawsuit and give them the opportunity to respond. Importance: proper service of process is crucial for court to have jurisdiction over a defendant and for the lawsuit to proceed. Who can serve process? A professional process server, sheriff, or sometimes a private individual, depending on state laws. Methods of service: personal delivery, certified mail, substituted service, depending on the circumstances and state rules.
Brother King, want to elaborate?
Okay, so this is one of the, like I said, it got to me. It has to be what they call procedurally sound. When the court don't follow this service of process, then that violates your due process because you have a right to be noticed, have noticed it, and right to be informed of what's going on, charges, right? You have a right to confront these individuals based on this right here. So you have a right to know what's going on. If they fail to serve you and then they get a judgment against you and without you knowing, then that violates your right of due process in which you can have it overturned based on the elements that exist that the brother has identified either under any of these captions, if you understand how due process works.
All right, next slide.
Civil rules of procedure. Pleadings. A pleading is a formal document that states the basic positions of the parties in a lawsuit. This stage is set when the person bringing the suit files a complaint. Jurisdiction. A short statement of the grounds for the court's jurisdiction. Claim. A short and plain statement of the claim that shows the pleader is entitled to relief. Demand. A demand for the relief sought, which may include different types of relief. Legal sufficiency. The pleading must show sufficient facts in short and plain terms that entitle the plaintiff to relief.
Brother King? King?
I apologize. I was just talking away and I forgot I had it on mute. The thing that individuals must understand is when someone is making a pleading, right, a complaint, that's a pleading, and they're pleading to the court to issue something against you, or you have a right to defend that pleading by being able to put your own pleadings in, or what they call a counter, right? So you can counter, right, and then you can and defend. You have a right to defend yourself in a matter that sometimes what people got to understand that law don't cover every aspect of life. There's some criteria that just the law can't afford to cover because there's so many scenarios, so many different situations in life that we come across that law don't necessarily meet every certain aspect, but it does cover. That's why I say if you learn about a principle, then you'll be able to narrow this stuff down and break it down, no matter what the circumstances is of the case. So when you understand how to motion plead and plead to the court, you will be able to learn how to properly perfect the claim. What do that mean? That you met all the elements necessary for due process and that you have particular facts that support what you're saying. You're not just saying that you got evidence. So when you're pleading in this, right, You just going to the court and making sure the court understand what you're requesting and how to articulate your complaint.
All right, next slide.
Civil rules of procedure. Motions. A motion is a formal request made by any party for a desired ruling, order, or judgment. Case caption. Identifying information like the court, parties involved, and case numbers. Title. A brief description of the type of motion being filed, e.g., motion for the summary judgment. Introduction. A concise summary of the motion's purpose and key arguments. Facts. Detailed presentation of the relevant facts related to the case, including supporting evidence. Legal arguments. Analysis of applicable laws and legal precedents to support the requested relief. Supporting evidence. Affidavits, exhibits, or other documents to substantiate the facts. Opposition to motion, if applicable. Arguments presented by the opposing party against the motion. Prayer for relief. A clear statement of the specific outcome the moving party is seeking from the court. So,
Brother King, you want to add to this, or I mean, elaborate? So,
Yeah, so
mhm.
understand when you motion pleading, you got to definitely have the proper caption in the case. Like you need to have, in the caption, you need to have the plaintiff, who you're addressing, their information, and yours. And then you want to have in the caption what type of motion you're filing, who the judge is, where's the court location. That you have all of that in the court in the caption. So when you file your plea in the court, don't dismiss your case based on your caption. Then let's talk about. Let me blow this up a little bit. Title, type of motions. You're gonna put in your title like what kind of motion you're filing. If this a motion to dismiss or whatever, a motion to suppress, you put that in. And then if you're going to file a summary judgment, you will put all that in also. Now let's go to introduction. A lot of people when you talk about your case, how I like to do it is I like to have my brief or my memorandum of law supported by facts with exhibits. That's how I do it. Facts of the case. You got to have the relevant facts that support your position. Legal argument. You're gonna talk about how the facts point your position and what you mess up to violate, how they messed up to violate the law or whatever. So you want to articulate that. Your legal arguments is based on res judicata, stare decisis, cases that already came before you that had, based on the same principles, you discovered that this case, based on the criteria and the principles involved, your case falls under that jurisdiction. Supporting evidence, you're going to have your supporting evidence, your affidavits of support, your affidavit of evidence. All that stuff is going to support your motions. Your supporting factors that support your motions. Opposition to motion, argument presented by the opposing party against the motion. So you get to argue whatever you want to argue against a motion based on defects in the motions, or they're not adhering to a particular rule, that they violate some due process. And then it's just you do an order or a prayer for relief. You're asking the court to give you some type of relief.
Awesome. Next slide.
Civil rules of procedure. Time refers to the various time frames and deadlines set within a legal case, including the initial filing of a lawsuit, pre-trial discovery periods, time limits for motions, and the duration of a trial itself, all of which are often regulated by specific rules and statutes to ensure a timely resolution of the case, sometimes referred to as a speedy trial right. No single set time. The time frame for due process can vary significantly depending on the severity of the situation, along with the type of case, civil or criminal, jurisdiction, and the complexity of legal issues involved. Balancing tests. Courts will weigh the individual's interest in due process against the government's interest in prompt action. Speedy Trial Act. In criminal cases, sets the time frame for prosecution, ensuring a trial is held within a reasonable time. There is no law similar to Speedy Trial Act that governs civil trial scheduling. Statute of limitations. Civil cases often have a statute of limitations which define the maximum time allowed to file a lawsuit after an event occurs.
Brother King, anything you want to add?
Yeah, like I said before, all of these things that you do, you have time. They call them time computations. So, like, you might file a post-trial motion. That's a motion after trial. You went to trial, you might have been convicted. You want to file a post-trial motion. You have to file it. They tell you the time frame when you can file that particular motion. If you outside of the boundaries of that, you got to show good cause, and then you have to show why you were delayed on that and explain it, right? Like, let's say if you had surgery and you was outside the time because you were still trying to recover, that could be a good cause shown in which you can utilize, right, an extension to properly file and get the court to grant the motion so you can get back heard. So all of these things, speedy trial is a time restraint. Balancing test, that's a time, right? So that's what they're referencing.
Next slide.
Civil rules of procedure, technical issues, refers to a problem arising from a specific detail or procedural aspect of the law, often related to the proper form of timing of legal documents rather than the substantive merits of the case itself. Essentially, a legal technicality that could impact the outcome of a case, even if the underlying facts seem clear-cut, sometimes due to minor procedural error or oversight by a party or the court. Focus on procedure. Technical issues usually involve following precise legal procedures like proper service of documents, correct filing deadlines, or adhere to specific rules of evidence. Potential to dismiss a case, even if a defendant appears guilty on the merits, a technical error by the prosecution could lead to a case dismissal. Can be controversial. The term technicality is often used critically, implying that a legal detail is being prioritized over the core justice of a situation. Examples: missing paperwork, a crucial document not being properly filed or served within the required time frame. Incorrect legal citation, citing the wrong case law or statute in a legal argument. Improper witness qualification, a witness not meeting the necessary criteria to testify on a specific topic. Failure to object at the right time, not raising an objection to inadmissible evidence at the appropriate moment during trial.
Brother King?
Yeah.
Mhm.
So here we go again with all of these technical issues. Can y'all hear me? So these are just things that I call errors, mistakes, omissions, and defects. You're looking for that in their case. So you identify these things and show where the law says this and they weren't doing that, causing a issue in law.
All right. That's it. Anyone? All right. Next slide. Yes.
Procedural due process, the elements of administrative rules of procedure. So these are the elements of administrative rules of procedure. Fairness and transparency. It aims to ensure that individuals affected by agency actions are treated fairly and have a chance to understand and contest the basis for those actions. Protection against arbitrary decision-making. By requiring established procedures, it prevents agencies from making decisions based on whim or bias, promoting consistency and accountability. Balancing interests. Courts consider the private interest of the individual affected, the risk of an erroneous deprivation, and the government's interest in efficient administration when determining the appropriate level of procedural due process. Evidence review. Affected parties may have the right to challenge the final rule in court through a process called judicial review, where a judge can assess whether the rule was properly developed and aligns with the law. Judicial review. Affected parties may have the right to challenge the final rule in court through a process called judicial review, where a judge can assess whether the rule was properly developed and aligns with the law.
Brother King.
Fairness and transparency. All of these things are balanced out from the rule of law. Due process was birthed from the rule of law. These give you standard of operation in which everyone must follow. So when we talk about fairness and transparency, that's what I'm talking about. You have a right to the nature and cause of action. The court got to be transparent. Are they operating from a jurisdiction unknown to you or to the appellate court? The appellate court has to know. If you don't ask questions or never bring it up on the court is going to assume that they got jurisdiction and assume that they're following or within the rules of the gambit of their authority, in which now you have allowed them to defeat your claim by not addressing it. Then we got protection against arbitrary decisions. Courts can't make a decision based on their feelings. They got to follow based on friendship. They got to follow and adhere to the law. Balancing interests. The court got to understand that keeping the justice system operating fairly, you kick down civil unrest. If nobody won in court and the court always won, then people will question the court and its balancing test, right? Just giving you some examples. Evidence for review. You have to have the proper evidence. Did the court consider your evidence? Right? And then last, judicial for review. Then you just ask the court.
All right. Next slide.
Administrative rules of procedure. Fairness and transparency. Fairness. Impartiality. Applying rules and standards consistently without favoritism. Due process. Following established procedures and giving individuals the opportunity to be heard before making decisions. Objectivity. Basing decisions on factual evidence and not personal biases. Equity. Recognizing and addressing potential disparities to ensure everyone has a fair chance. Transparency. Open communications. Clearly explaining decisions, rationale, and criteria used to reach them. Accessible information. Making relevant data and details readily available to all stakeholders. Accountability. Taking responsibility for actions and providing clear explanations when necessary. Clear guidelines. Establishing well-defined rules and procedures that are easy to understand.
Brother King.
Yeah. Okay, administrative rules of procedure, fairness and transparency, impartiality. That's what we talk about. A judge has to be impartial. He got to be neutral, right? Then he has to adhere that everyone is following the rules, due process, objectivity, um, basing decisions on factual evidence and not personal bias, right? They have to use something actual. That's why affidavits and exhibits is very important. Equity, looking at how the law was supposed to be applied equitably, and they use other case law to determine how to sometimes iron something out based on the particular elements, even to disperse funds, to help them get adjustment on, okay, this case is very similar to this other case. Let me read that one, and then I read this one, and then I have uh, uh, a particular type of evidence. My apologies. And then the court gotta have open communication. They gotta communicate. The judge just can't make a ruling and just lock you out. Accessible information. You have the right to have access to the court paperwork and documents that other parties filed. The court has to be accountable for what they did, how they went and ruled upon you. And then clear guidance. Then you have to know the rules of procedures thing which guide you in order to ensure the integrity of the process.
All right, next slide.
Administrative rules of procedure, protection against arbitrary decision making. Notice, individuals must be informed of the potential actions against them and the reasons behind them. Opportunity to be heard. Individuals must be given a chance to present their side of the story and defend themselves. Neutral decision maker. Decisions should be made by an impartial body, free from bias or personal interest. Established standards. The government must apply clear and consistent rules when making decisions, not acting on whim. Reasoned decision making. Specific instructions on what information should be included in a comment, such as personal details, relevant concerns, and supporting evidence. Public hearing, optional. A dedicated meeting where individuals can verbally express their opinions on the proposal. Response to comments. A statement from the decision-making body outlining how public comments were considered and incorporated into the final decision.
You know what, King? You definitely see the rule of law here as a foundation.
Yeah, the rule of law, it's just, if you look at this, it's just redundant, right? And you will see the rule of law is in due process altogether. And you will see these things administrative. If you once you understand with due process, you will be able to, once you start studying it and understanding the elements of it, then you will be able to link it back to the rule of law and how the rule of law governs this. And this is all the court due process is really an element of the rule of law.
Mm.
So if you look at everything he's saying, it's kind of like it's hitting the same points over and over again. It's just more defined, but it's the same thing. This is what I follow.
Yeah, it's more fun. Yeah, more. Yeah, I see. See.
This makes it very so. This is a good study material to study from, right? Because now you got something to show you how the law should be operating. Then you can understand the application that's being utilized. If that application violates a right, right? Fundamental principle. A lot of people don't understand the operation, the components that move the law. They don't understand. It's like having an engine. And most people don't know, when you don't know how the engine's supposed to run, you don't know the pieces, and you don't know the function. So you might blow a head gasket due to not having your car overheat. You don't have enough oil, coolant in your your car because a person didn't know that they could take the top off and not know that they're supposed to have coolant and it cracked their motor because they didn't know what they were looking at. When you understand this, you start to know what you're looking at and you can look for the things that's not there. That makes sense?
Yes, yes.
Yep.
We'll go to the next slide. That's good.
All right. Administrative rules of procedure, balancing interests, identifying relevant interests. The first step is to clearly identify all parties with a potential stake in the decision, the specific interests they hold, including the agency's goals, the public interests, and the rights of individuals directly affected by the proposed action. Analyzing the potential impact for each interest, assess the potential benefits and harms that could result from the proposed agency action, considering factors like economic impact, social impact, and environmental impact. Applying the balancing test, weigh the competing interests against each other to determine the most appropriate course of action, considering the relative importance of each interest and the likelihood of harm occurring. Due process considerations. Ensure that all affected parties are provided with adequate notice and opportunity to be heard throughout the process, particularly when significant interests are at stake.
So you remember how we looked at Mike's case, right? And Mike having some issues,
Uh-huh.
right? When they're not trying to return the vehicle. These are things that right off of here they tell you what to do. It's the first clear step to identify the parties, right? One of the parties introduced a motion that they didn't identify themselves or their rights to be able to show the source of law that gave them that right to do that action, right? These are things that you have to look at because these are things that would disqualify certain things, certain statuses, based on failure of giving certain notice. Right to see, a lot of people don't know that when a person come into a case, they have to give a notice of appearance. You don't just get the appeal, especially when you're an attorney representing somebody. They have to give a notice of appearance. They got to give you notice that this person is representing this other party. Failure to do that is violates due process. And these things right here, looking at the case, that's why I say once you understand these components, you will have a better understanding of how to analyze the case and show what was missing, how the case was based on errors, defects, omissions, and mistakes that this case need to be disqualified based on these due process issues. Violation of due process in every component spilling over into the rule of law, and which is the superior rule.
Right on. All right. Go to the next slide.
Administrative rules of procedure, evidence review, relevance. Evidence must tend to prove or disprove a fact that is at issue in the case. Materiality. The evidence must be important to the case and relate to a significant fact in dispute. Competency. Evidence must meet legal standards for reliability, such as proper authentication and not being hearsay. Balancing test. Even if evidence is relevant and competent, the court may exclude it if its probative value is substantially outweighed by the risk of unfair prejudice, confusion, or waste of time. Types of evidence that may be reviewed in court. Testimonial evidence, witness statements given under oath. Documentary evidence, written documents like contracts, medical records, or emails. Physical evidence, tangible objects like weapons, fingerprints, or drugs. Demonstrative evidence, visual aids like diagrams, charts, or models used to explain complex concepts.
Brother King?
Okay, so evidence got to be relative, right? I want to talk about this. You can't use evidence that don't relate, right? You got to the evidence got to correlate to the actual events. Then, when we talk about materiality, the evidence, right, must prove, right, or it must have supporting factors or elements that you can use to support your claim, perfecting your interest in property or perfecting or protecting a right that you have that was guaranteed, right, by the Constitution. It don't have to be guaranteed by statute. The Constitution is what trumped that. That the state might be in violation of your right when they due to the creation of a statute that interfere with a fundamental right or principle. Um, Competent, when we talk about competent evidence for reliability, we want to know what's when this person made this statement, right? It has to be authenticated. What does that mean? If that person if that person wrote the affidavit, they had to come and then authentify it by having some type of testifying to the content of it, right? Subpoenaing them to court to testify to the content of what they're saying in their affidavit, explaining or expressing what they meant, and furthermore, validating that they have a right to do that, like showing their ID and stuff like that. If they're not illegal alien or something, that may not have the right to exercise such jurisdiction because they're not a lawful resident or something. Those things can be looked at and be challenged. And then the balancing test, right? If evidence is relevant and competent, the court can exclude it for its probative value if substantially outweighed by the risk of unfair prejudice. And what does that mean? That evidence that wasn't submitted, or sometimes the prosecutor will introduce evidence that you weren't aware of that you don't have the right, you didn't get the challenge. And that evidence may lead to your conviction that could be overturned because you didn't have, you was done, they hit you with something that was surprising, that you didn't have a right to challenge or defend against, and that they introduced it into the court record that day and heard it at trial. That's a violation of your due process. So when we talk about what types of evidence, testimonial, documentary, and physical evidence, and demonstrative evidence, we got to look at how they're being used to express, and how the person who is identifying the evidence, how they're connected to the evidence through their expertise or through their firsthand visual of testimony, because they had firsthand knowledge of the actual events because they were present to see it and hear it. These things are very important to qualify the evidence based upon that person being there, right? And show that that person don't have a interest that is questionable. Somebody might do something and lie on or perjure themselves on the basis that they may not like you. Like, say you have an ex-girlfriend that come in and testify against you when y'all broke up based on something that she's saying that she witnessed and that she wasn't a part of for whatever reason, to get vengeance at you. You can cross-examine her and have her come to court, and you can, like, let's say her cell phone, and let's say her cell phone identified the day that she's saying that she witnessed something, that you can actually subpoena her phone records to show she was in a different location in a different place and time when the event happened, that she never seen it, challenging the authenticity and that she perjured herself based on making a false statement. Just giving you an example of something that you can use that may be applicable, an idea of what you can do.
All right, all right. Next slide.
Administrative rules of procedure, judicial review, Marbury versus Madison, 5 U.S. 137, 1803. Primary holding. Congress does not have the power to pass laws that override the Constitution, such as by expanding the scope of the Supreme Court's original jurisdiction. Purpose. Judicial review. Decisions should be made with a serious attempt to understand the Constitution. Grounds. Traditional grounds for judicial review include legality, irrationality, and procedural impropriety. Standards. Some standards of judicial review include de novo review, reasonableness review, and abuse of discretion review. Deference. In some cases, a federal court may defer to an agency's interpretation of a statute or regulation. See next slide. Procedural fairness. A decision can be overturned if the process leading up to it was unfair. For example, if a decision maker was biased or didn't give someone a chance to make representations. Irrationality. A decision can be overturned if it is so unreasonable that no reasonable person could have made it. Human rights. A decision can be overturned if a public authority has acted in a way that is incompatible with human rights.
Brother King.
So, some of the same points that I've been making is redundant. So, if you see the pattern, I want y'all to look at this. When you look at this, see what if you go back and look at everything I've been talking about from me being on the Moroccan Post as I present this evidence, the stuff is just redundant. I'm trying to make it so simple that you can walk away with this and pretty much pick it up real easy. So if you look at the stuff, right? If you look at how, like I'm gonna talk about my case, how irrationality, right? The court overturned if it was so unreasonable that no reasonable person could have made it. The thing that you have to be able to, it's an art. I want y'all to understand. It's a form, it's an art of expression. You have to be able to convey this in such a way where it's compelling. You're compelling the court to act and rule in your favor because you know these principles and you identify these principles so good that they couldn't overlook what was missing, and that you had expressed it in such a way that it was compelling and it's profound. You have to understand how to practice this. This is an art form. I want you to take it literally, like this is really like writing is very important to expressing how you able to convey this information to a court. If you don't know how to convey it, it's not going to make sense to them. When you start talking about all of these different things, that's why when we talk about human rights, and as that's the last one, a decision that can be overturned if the public authority has acted in such a way that is incompatible with human rights. How is being black compatible with human rights? Show me where it's compatible to human rights. When black is no kind of component of has any national standard or principle that is outside of any human existence. There was never a black nation or a group of people until they identified people as black. Stripping them, that's a genocide term. Stripping them of a nationality. and putting a label or a statute. That violates human rights. How do black fall into this category? Don't black violate human rights? Being black? So we got to look at this, right? From once you understand these things from this perspective, you will be able to think what they call reasonably. You see what I'm saying? Of good conscience.
Yeah, let me just go more to that, King. I'll be looking at, and it's absolutely so would be and that can be brought against in world court. Let's look at Spain, for example. Asiento de Negro, that was drafted by the Spanish crown, that governed, that subjugated, where they subjugated the Moors under the Asiento de Negro. And Negro is used for inanimate objects. You have the Code Noir, the French crown Code Noir of 1685 in the Caribbean, applied in the Caribbean, where subjugating Moors in the Caribbean under the French crown subjugated the Moors in the Caribbean under the Code Noir, Noir, black codes. Then you have the French subjugating us under the French crown's Code Noir of 1724. So this is actually the official name, Code Noir, black codes. In 1865, all of the member states of the Union States of the United States adopted the 1724 French Crown Code Noir in 1865, black codes. So this is actually official documentation that we can use, bring up a case in world court. We never classified ourselves as black. And so I remember our people, because they've been groomed, because we've been stripped of, black has no national character. As King says, that there is no national character. In fact, in the Dred Scott case, I think Justice Wilson had mentioned, and in his opinion regarding the case, that African descent there's no national characteristics. There's no national character. So black, there's no national character, meaning, let me explain national character. National character, Chinese, French, English, Irish, German. And so those nationalities are drafted in national constitutions. The people of China, the people of France, the people of Germany, the people of Ireland. They're drafted within a national constitution. Flag, the seal, their national coat of arms is drafted within their national constitution. And that which is not drafted in a national constitution is legislated by Parliament and or Congress. So they become part of the national characteristic. More is not an individual identity. There's nothing individual about Moor nationality. Nothing individual. It's a collective. So Moorish nationality, that's a collective identity, not individual. with Moorish nationality. It's pre-existing. It's pre-existing. So there's pre-existing claims, pre-existing protection. So understand, German nationality, French nationality, there's nothing individual. So you have the national character that's tied to the German nationality or any nationalities. There's nothing individual about it. Our situation as a people is unique because we've been stripped. The Moors have been stripped of every aspect of national character. And because it's gone on so long, not 2 years, 5 years, 10 years, 30 years, 40 years, 50, 60, 70 years, 100 years, 130 years, 150 years, it's 100, over 200 years. So also the length of time. This is a unique situation. The remedy's there. The remedy's there in international law. Remember, it's a pre-existing. So there's no scratching the head. There's no pulling hair out. What do we do? Which way do we go? Which way do we go? There's the principle there. So you also have millions of our people who don't know they are. So you only have a small percentage, and we are among them. A small percentage that know who we are. We have to change the percentage. We have to increase the percentage now. We have to increase the percentage, but it's a small percentage. So we are in a unique situation here. The kingdom, the native people of Hawaii are not in our. The native people of Hawaii cannot relate to us. Yes, they've been subjugated since 1898, since 1893, but they have not lost their national character. They have not lost every aspect of their national character. Their kingdom has been dismantled by the United States in 1893, but they have the knowledge. They still, all right. When the United States subjugated the people of Hawaii, the United States allowed the people of Hawaii to remain, to keep the culture, the rituals, the celebrations, the dance, the language. The United States allows for that. The United States did not strip, the native people of Hawaii of everything. Of everything, where United States did not take the children away and say, you are yellow. You are yellow. So you don't have people, the native people of Hawaii not saying, yeah, say it loud. I'm yellow and I'm proud. Woo, woo, woo. Say it loud. I'm yellow and I'm proud. Like, you don't have that. But we've been stripped of everything due to France, the French crown. But when we talk about our situation, we cannot start with the United States. We can't. That's an error. Please hear me. To begin with the United States in any situation regarding us, to begin with the United States in any situation regarding us would be an error. Please, my brothers and sisters, not only hear me, but I will present documentary evidence. It's an error. We're only doing that because we lack knowledge. I don't just see United States because of the knowledge I have. I don't just see the United States because of the knowledge I have. So it's a lack of knowledge. I see France. I see Portugal. I see the Dutch Republic. I see the Netherlands. I see England / Great Britain. I see that because of the knowledge. Most of our people lack this knowledge, so they say United States. Oh yeah, slavery. United States. United States, slavery. Man, damn. 1620? The United States, yeah, you know what, king in Israel. In 1620, United States, yes, United States in 1620. Yeah, United States held us in chains in 1620. Yeah, in 1710, the United States, Abdullah, Dummy Abdullah, United States didn't exist in 1620. That's my point. So I would say something like that, because I want somebody to call me dumb. I would say something like that just to get their attention, to make the point. So I will say 1610 United States. They make my point. That's the point that I'm making. I yield.
So when you get into this aspect, it would lead you into a higher understanding. So when I got into international law, I was able to unravel that as well as I can unravel law within the boundaries and the confines of the United States. You got to understand the language that they use, that they why did they miseducate us? To keep us in to cement us in a state of subjugation. Cement us so we can't move. They educate you on slavery. There's no such word in international law as genocide. If you go to the international court talking about slavery, there will be a moot issue. There is no original jurisdiction for slavery. That term is not used. That was a codified. You know how a lot of you guys, y'all attempt to coin these phrases, status correction, administrative process, all of these different things. But you can't find this in law anywhere. Status correction. That's a coined term. So it has no applicability in law. So it becomes mute. That's what they did with slavery. It's a coined phrase that they utilize to teach you about showing their intent. This is gross negligence on their part. Showing the grossness due to the longevity of the injury that they submitted themselves in over and over and over, that this is gross negligence. It ain't just negligence, it's gross. It's an intentional affliction of harm. Because to strip a person of nationality is like stripping them to death. It's considered cruel and unusual punishment by all means on an international and national standpoint. It's cruel. You can't get no crueler than that. To strip a person to an identity that's unidentifiable anywhere. There's no black nation. Slavery is a coined term to keep you submitted in a condition of servitude.
Yeah,
What's
yeah, you're right, King. Subjugation is the international
term?
to conquest. When you all right, we have all right. Let me give support to what King is saying. All right, so we're gonna look to international law. You have international law, the law of peace. You have international law of war. And under the law of war, you have laws of sovereignty. Under laws of sovereignty, you have there's conquest, colonization, subjugation, and annexation. Annexation. You have those. That's loss of sovereignty. And the international law of peace, the converse of loss of sovereignty is known as, in the international law of peace, the recovery of lost sovereignty. You also have the reversion to sovereignty. Post-millennium falls under war because that's a aspect of captivity in war. In post-millennium is the international law principle of restoration, of returning a people to their original condition and status at the time in which it was lost. It's post-millennium. United States should never come up. Never. The United States, when you're talking about recovery of lost, when we the Moors talk about post-millennium of recovery of lost sovereignty, United States should never come out your mouth. United States Constitution, United States should not come out your mouth. If I hear United States or United States come out in more mouth, I already know they don't know what they're talking about. I don't care who they are. Once I hear when we talk about post-millennium, or reversion of sovereignty, or recovery of lost sovereignty, or bringing us back into restoring us, and I hear United States Constitution, I already know they don't know what to talk about. This is before our status is before the United States Constitution. Our political power is before the United States. Our operating in government structure is before the establishment of the United States Constitution, before the establishment of the United States. Go to Moorish Mondays Part 1. The treaties, the Moorish treaties, the treaties between Morocco and Great Britain, England/Great Britain, between Netherlands, between Algiers and England. Those treaties protected the English merchants. This is the 1600s, going back to the early 1600s, all throughout the 1600s, 1710, 20s, 30s, 40s, 50s, 60s, 70s. Those treaties protected the English merchants, captains and sailors. The English ships that left our land along the Atlantic seacoast and sailed to England and the Mediterranean. But those Moorish treaties that I have in Moorish Mondays Part 1 protected the English ships, the English subjects, the English sailors and merchants. This is before, we're talking about 1600s now. I'm pointing to documentary evidence, finding of facts, that our power is before the establishment of the United States. So if you're talking about recovery United States should never come out your mouth as a remedy. Like you're pointing to United States Constitution as our remedy. That our remedy, that the recovery of our lost sovereignty, that our salvation, our everything is in the United States Constitution. How was we before the United States? Treaties, wars, captivity ransom, our seasoned ships, diplomatic relations before the establishment. This is not complicated, my brothers and sisters. What it is, what I'm saying is not complicated. What it is, because conscious Moors like myself, I gotta raise my hand. Because of conscious Moors like myself, I will always raise my hand. Who taught y'all, I'm included, misconceptions. So I'm including that. I'm raising my hand. I will always raise my hand. Because of people like me who taught y'all misconceptions. That's what that is. We've been cemented in misconceptions, misinformation for over 100 years. Include me. I taught misconceptions for 25 years to thousands of people. I'm making amends for that. So I will always include myself in that. Brother Hank.
Islam, Brother Abdullah, Islam to the family. I was monitoring from backstage, and the brother said, why a Moorish man cleaning a spaceship? This is just to lighten it up a little bit and project future manifestation. Moorish Marquise. All right. And my reply was, Marquise, the Moor is polishing his spaceship for travel. Brothers don't be traveling no dusty ships. Polishing the pulse light projector. If you're interested in acquiring one, I'll get you a cool hookup.
All right.
About this. You got to visualize.
Talk to me, brother.
To materialize. Because Moors never rode in dusty ships. If y'all can get the idea. We had our stuff polished. Back then, now, and in the future. That's all Uncle Hank got to say.
I appreciate you, brother.
I'm out.
All right, so we can get right back to it, Israel. Are we done?
This last slide, and that'll be it for the administrative rules of procedure.
All right, last slide. All right.
All right. So administrative rules of procedure, judicial review, deference. Deference. In some cases, a federal court may defer to an agency's interpretation of a statute or regulation. Chevron doctrine. This doctrine from Chevron USA, Inc., 1984, directs courts to defer to an agency's interpretation of a statute that it administers unless the interpretation is unreasonable. This doctrine was overturned by the U.S. Supreme Court on June 28, 2024, in the case Loper Bright Enterprise versus Raimondo. Loper Bright Enterprise versus Raimondo, primary holding. Courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority. Courts may not defer to an agency's interpretation of the law simply because a statute is ambiguous.
All right. So this, you said this is the last slide, or this is the last slide for the administrative rules or procedure?
Last slide for the administrative rules of procedure.
Oh, it's not. All right. Not the last slide. All right. Brother King, you want to elaborate? All right. Mm-hmm.
So when you understand the rule of law, we're going to go back to due process. This was never constitutionally sanctioned. The Supreme Court was the only person that can interpret the law. It never gave authority to agencies to have such power. We talk about the separation of power doctrine. So under congressional ruling, this is why I talk about congressional overreach. They allow them to interpret statutes. Where do they say that in the Constitution? When you understand these principles, you can go back and you can start unraveling a lot of the grave mistakes. But when you're ignorant to the law, they get by on this stuff. And now what they do is they hope you lock yourself out by allowing time to go by. And then it's called a time computation that you didn't follow, adhere to the rule. So now you're trying to raise an issue that you was now the court saying is mute because you never raised it in the lower court, or you out of time to even file such action according to the rules because of your ignorance. And this will happen to a lot of brothers who are innocent in jail. They don't understand the rules, so they don't know how to play the game. Even if you fail to identify the nature of the action versus the cause. If you don't bring it up, it becomes a mute issue in court. It has no constitutional basis because it wasn't constitutionally challenged in the court, in which the Supreme Court would say it's mute. This don't have nothing. This is not a interest. This is not a interest of justice. You have no grounds, no basis, because now you're out of time. You didn't follow the rules, so now you don't know how. Since you don't know how to play the game, you fouled out. Y'all see how this works when you understand this stuff on a level that I do, Brother Abdullah do, Brother Israel, as he did a marvelous job presenting this information. So it looks like there's going to be a part 2 to this. When you understand and break this down by the principles, not just by face value, looking at a statute, looking at the Constitution, looking at how the Constitution, the words in the Constitution. No, you must understand the substance. What do I mean? You got to know the principles of what's injected into that instrument, and that instrument is governed by a set of principles, not just mere words. And once you adhere to these principles, you'll see these principles everywhere you go. It's like I'm Neo in the Matrix. I don't look at the words. I'm looking for the principles. When I'm looking for things in case law, I say, oh, they violated such and such and all of these different principles that they were supposed to follow. Because now I can see that. But you have to study by this set of understanding, understanding these principles. That's why Abdullah said, Brother King, now I can understand how they write constitutions based on this information. I could go and look at stuff universally on an international level because I understand these things a little more better and clearer now. Understand what you're saying, King, why you study in this format. This is why I'm able to go and say I've been winning for years, because I understand these principles. And the principles are not a respecter of person. I yield.
Yeah, we're gonna have a part 2, because I don't want to go. We're not gonna go past 2 hours. We don't want it that way. We can, we'll have a part 2. So we'll bring you back for part 2, King. Like I got someone, Elkanan will be on. Elkanan Bey will be on next week, and I have Brother Khalil. Brother Khalil will be on December 30th. Sister Nitra on the 6th. So we'll have you on the 6 plus 7 is 13. So King will be back on for part 2, January 13th, Monday, January 13th. Due process, the key to freedom, part 2. Due process, the key to freedom, part 2. King El Bay, and we'll have Brother Israel who will be doing the reading. Brother Israel, once again, bro, I want to thank you, man, for putting this together for us. Brother took the initiative and he put this together. And so I said, yeah, let's get this there. Let's get it cracking with King. Absolutely. So this great. King, you did once. Well, as always, King, you knocked it out the park.
Thank you, brother.
Knocked it apart. Brother Israel, is he still with us? He leave us?
I don't know.
That's all right.
Here we go.
Oh, there you go.
All right. So what? Tell you what. Well, King, we got a few because we won't go past 2 hours. So King, talk about the upcoming course. We talk about the upcoming course, the trust and contractual legal safeguard, King. So, which is May 8th, March 8th, 2025.
So this
Let's
course,
start. Yeah.
This course would teach you understanding what is a trust and why. What's the purpose of constructing a trust? So you can have essential information to how you want to set up your trust and the particulars of what the trust is instituted for. And you must remember, trust has to contract like any other LLC or any other thing. So now you must understand the safeguards that you got to put in there, like a severability clause. Why is that important? Because you don't want to make your contract totally void when you don't have that clause in there. So you want to state in that severability clause why that's important, so that it's may state in that severability clause if any provision of this contract is found to be not contractual, the rest of the contract shall remain intact and enforceable. But if you don't have that in there, that can cause your whole contract to be voided. Now your contract don't have no force of law because you didn't have nothing in there to safeguard all the other provisions. You see, I'm just giving y'all just an example, a little taste. Important by the legal safeguards. You know what I'm saying, Abdullah? Just giving them a little safeguard.
Yeah, that's what I want you to do. So we can reel them in.
Right. So when you don't have these things in your contract and you don't understand these legal safeguards, right? You don't know how to draft your contracts. And now you left a lot of open space where somebody can come in and pierce the veil of your trust and take everything out of the trust because you didn't know how to contract. You don't have an indemnity clause for your trust that owns an LLC in which now is protected under an indemnity provision because it's excluded for anything that LLC does. See, I ain't gonna give no more now. Y'all gotta come to the class. You gotta come to the class. Get the business, right? You gotta get the business. So now I'm just showing you things that you have to do in constructing contracts to show legal safeguards, right? So I could go on and on with different provisions why that's important to have these in your contract. And most of y'all don't. Most of y'all think you gotta trust. Hey King, I gotta trust. I got 50,000 page trust. And I'm like, okay, why?
50,000 page trust.
In my trust, it got stuff in it. But you don't know how to contract your rights. You then gave another entity the right to go in there and pierce the veil of your trust and gave it rights because you didn't know how to safeguard the rights that you had in your trust. This is how these corporations is getting into your personal affairs and stripping and owing you money because you don't understand how to safeguard your rights. Because you didn't put provisions in your contract to ensure the integrity of what's going on so nobody can come in there and pierce the veil. You can say, hold up, wait a minute. Here's the contract. I gave them notice of this. I'm showing them how I'm moving. Here's the property that was attached to this. Here's my UCC file and give a notice. All they had to do is look at these provisions and understand how this contract was operating. They failed to do due diligence. That's not on me. See how that works? This is why I say y'all got to come to the class. Come to the class. Learn some more.
Hey, Brother Israel, can you put the link into the chat? The Eventbrite link into the chat?
Yeah, we got on deck right now, but
all right, no problem. Who's ever on that can put the link into the chat? Help us out here. Put the Eventbrite link into the chat. Amanda, if you're on, right, serious. Brother Obadiah. Who's usually on? Obadiah, Brother Quasi.
I might be able to find it. Hold on.
Yeah, put the Eventbrite link into the chat. Yeah, somebody will do it for someone.
Yeah, I think I found
Because
it.
they all have their link. They all have everybody name when I name has the yeah. So this is the 12-week course. We're going to be on Saturdays, starting on March 8th from 2 p.m. to 5 p.m. Eastern Standard Time. 299 notes for the course. So get your ticket soon. And we'll continue to market it.
Get your ticket.
So definitely look forward to seeing y'all next week with Brother Elkanan Bey. Brother Elkanan Bey will be with us with his Masonic, with Masonry, Astronomy, and Mathematics series. 33rd degree, 97th degree, past Grand Master, York Rights. So definitely excited for next week. All right, so we're going to we're going to end. Go ahead, Brother King.
I'm gonna give one more.
Yeah, please.
So tell you how you need to be thinking when you come to this course. Right of publicity clause. Most of y'all don't have a right of publicity. You know what that means? Giving somebody the right to use or exercise a name that's under contract. A lot of y'all don't even know how to do that. You don't even have your name contracted out where other entity has the exclusive right to use that right of publicity as an identity to do business in. Right? And that the trust shall benefit from any proceeds, right, of the use of such name in such commercial practice. And that the third party who's using such name owes an obligation of discharge of any debt due to the such right and due to such rights, where they now have to offset and discharge any and all debts associated to this due to this obligation, due and giving the individual the right of relief at any given time upon notice. I'm just giving y'all a little sample off the dome. Gotta learn how to contract, family. So at that, I'm just want to show everybody, me and Abdullah have reached another level because we've been working together, teaming up, right? We working iron sharpens iron, right? I
Mhm.
brought the element that he didn't have, and I definitely he brought an element that I know I didn't have. Now I grew into I grew into another level of understanding on international law and concepts, and I'm still learning from this brother. I am so grateful that me and him was able to have a meeting of the mind and be able to study and work together. Now it just enhanced my understanding of law to another level, right? Blossoming my growth and development. That's all I want to say. You know, y'all getting information that you got 5 year graduate law students. They're not getting this. They got PhDs, and they're not getting this kind of information. I'm talking about you getting a level of understanding that a lot of the lawyers with doctorates don't even have. Like we're giving you insight into international laws and studies that I haven't seen nowhere that Brother Abdullah is bringing, complementing my understanding of operation of law through the rule of law, through the proper concepts, and killing all misconceptions. Because most of us don't know nationality from a principle of political points of view. We think that just because I'm a Moor, I say I'm a Moor, that supposed to mean something. We don't even understand it. So we're talking about we're gonna go into the federal courts and we're gonna sue them out their pants and underwear. And they look at you and they say, is you slow? You really believe you're gonna do that? So now I thank you again, honors to Brother Israel. Man, you did a magnificent job with this information. You did a magnificent job. The study and research that you have put together with this information, it made it easier for me to explain it because you put it together so well. So I'm thankful, brother, that you took the time to even present this, and it's honors and hats off to you, brother. I appreciate it. So
Gratitude.
thank you, my brother, and honors. So I just wanted to say that
He
I
did a wonderful job. He did an excellent. Oh, yeah, definitely. And this is the help that we need, man. This is the man. Absolutely, it was great. You know,
yeah,
great. And then like I said, we got it. We got part two, so we already set for part two. You know,
right.
and we just gotta wait till January 13th because I already have lined up for the next 3 Mondays. All right, so what's been strolling across the screen all night long for the past 2 hours. Anyway, on my website, mooresandmasonry.org. For my books, go to that website, mooresandmasonry.org. All right, so Eventbrite link will be shown in the description. All right, thank you, Hank. Thank you. Uh, Once again, always thank Brother Hank for his support. He's with us, man. Brother Hank is with us. Definitely the support. The support is greatly appreciated. All right. I thank y'all, the audience. Please like this video as well as other videos that's on the Magnet Crystal Pyramid YouTube page. Please share, post it on your social media platforms. All right. So this is part one of Due Process, A Key to Freedom. Will be part two, Due Process, The Key to Freedom, on January 13th on Magnet Crystal Pyramid YouTube page with Abdullah Iltili Mosi Bey, Moorish Monday. All right, thank you again. Peace, everyone.